So if a client asks about the case not going ahead on the day because the tribunal hasn't got the time, what we tell them is that it's unfortunate because there's nothing we can do about it. It's outside of our control. The reality is that the tribunal lists more cases than they actually have judges to hear. They do that because cases settle and because they've got a lot of cases to deal with, particularly after the removal of fees and what have you. So unfortunately, it's a wasted day and it's wasted costs. If a claimant doesn't turn up on the day, then the tribunal has a number of options. We can, from a client point of view, try to influence the tribunal, but ultimately it's up to the tribunal. The tribunal can continue with the case in the claimant's absence. The tribunal can postpone, can adjourn the case for that day and relist it another time. In the extreme, the tribunal could strike the case out because the client isn't actively pursuing. That would be draconian. The most likely step is for the case to be postponed. The tribunal would probably want to explore with the claimant why they didn't turn up, and then will pretty much excuse most things. So I think the case would be adjourned. Well, if during the proceedings it's been apparent that the claimant hasn't been, let's say, participating in the proceedings by not turning up, by not responding to letters, by not following the timetable for the procedures, then it's more likely that a tribunal will be sympathetic to a submission that either the case should be heard in the claimant's absence or that the case should be struck out for non-compliance. But again, the reality is that there's a fair degree of latitude, and claimants can get away with quite a bit before the tribunal takes draconian steps.